Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So the first one I want to chat about today, Phil, is one that I'm involved in personally. I'm not going to obviously identify the clients, plural, but I do want to talk about the nature of the cases. You probably remember me talking quite a bit during the last NLRB governing group. General Counsel Jennifer Abruzzo, she had
you were a big fan of Jennifer, if I remember correctly. You even had her as a speaker at your conference several years ago, right?
Yes, she was there actually. Yes,
that's right. And she didn't change your opinion.
No,
yeah.
No. So in 2023, and then again in 2024, she had issued some memoranda governing or discussing the unlawfulness of non-compete agreements, and to a lesser extent non-solicitation agreements in the employment arena. And basically she had advocated for a position that those are largely invalid. And so she had issued these two restrictive covenant related memoranda. And just on February 14th, a few weeks ago, the NLRB's acting general counsel, William B. Cohen, rescinded those two general counsel memoranda of Jennifer Abruzzo. I have two very nearly identical cases right now where the NLRB had already issued a complaint in one of the cases advocating that the non-compete agreement in the case was overly broad. And so that is supposed to go to trial. I think it's in mid-April. And then I have another one where the NLRB was investigating whether the non-compete agreement, non-solicitation agreement was violative of the law. And up until about a few days ago, the NLRB had not yet issued a decision in that case. So I got a call from the NLRB's board agent, I think it was late last week, maybe even on Friday, and he told me that the NLRB has decided not to issue a complaint on the restrictive covenant of non-compete and non-solicitation. The board is saying they're not going to pursue that. The normal process is they've gone back to the union, told the union that they're not going to pursue it, and so the union, according to the board agent, is going to be withdrawing those allegations. And if the union doesn't withdraw the allegations, the board will end up dismissing the allegations. My other one that's supposed to go to trial in mid-April, we are now going to be filing, and we were going to be doing this anyway, but we are going to be filing some motions to either stay the case or dismiss the case in its entirety based on the general counsel's guidance on non-compete agreements, her memoranda, the former general counsel's memoranda, being withdrawn. So the point of all of this is that under the Trump administration, under the Trump NLRB, we are seeing the NLRB dramatically back away from trying to enforce the NLRB or the National Labor Relations Act on restrictive covenants such as non-compete agreements and non-solicitation. And my counsel or guidance on this is that this is going to return to being the province of state law, and unless the federal government, the legislature, would ever decide to act in this arena.
So chances are some of the caution that we've had because of the position of the NLRB might be returned back to kind of state law and state interpretation. Again, I think what that says is trying to guess that right is probably not our best guess. Working with AAIM or Ogletree, and I would just say when we have these, we work directly with Ogletree, and we have these looked at, once a year or so by Bert, and every year there's, something that is better understood in case law that helps make the changes to give us, I think, the confidence we need that we're trying to do the right thing the right way. Yeah. But it does take a little bit of it takes review every year, if not even more than that, depending on how often you're doing these things.
Yeah, it does take review on a timely basis, regular basis. But I think that in light of this, and also with the court's rulings last year regarding what the Federal Trade Commission under the Biden administration was trying to do with non-compete agreements, which the courts invalidated the Federal Trade Commission's efforts in that respect. This is a marked return to normalcy with respect to the area of restrictive covenant agreements.
Very good. All right. What else you got there, Bert?
All right, so that was a personal one. The other one, we're going to talk about an area where the pendulum is swinging wildly, and I'm going to talk about one which has nothing to do with labor and employment law first, but we've been watching the Trump administration's efforts to fire a lot of the federal employees. We're reading decisions about some courts are upholding these decisions, other courts are rejecting these decisions. And I think what's interesting about this is that we're seeing kind of the political bent of the various judges come into play here, which to me is nothing new. We've always said that, when like for instance, the Supreme Court, when they decide cases, of course, the court is going to the cases are going to somewhat depend on the political bent of the judges who are deciding those cases. And so when the Republicans have a 6-3 majority, Republican appointed justices versus the Democrat appointed justices, we expect to see the court to be a more conservative court. Doesn't always play out that way. There was a decision just yesterday or the day before, a 5-4 decision against the Trump administration's actions regarding payments from USAID, USAID. But again, it's nothing new that we see sort of the political bent of the judges coming into play, but it's interesting how it's playing out now with these terminations by the Trump administration. And so what happened was there's an employee named Hampton Dillinger, and he was an assistant attorney general for the Office of Legal Policy under Joe Biden, and he was also the special counsel to the Office of Special Counsel. That is different than
okay. I like it. No, that sounds really really twisted, doesn't it? Yeah.
So what happened here is again, and this is not a special counsel that's appointed by the U.S. Attorney's Office, the Department of Justice to investigate things. This is a separate position, but Trump had fired Dillinger. And he brought a case against the administration challenging his termination. And a judge who's been quite active in the January 6 cases, Judge Amy Berman Jackson, ordered the Trump administration to reinstate Dillinger. She did this just this last Saturday. The D.C. Circuit Court of Appeals, the Trump administration appealed that, and the D.C. Circuit Court of Appeals just yesterday said the Trump administration could fire Dillinger. And so, again, we're just sort of seeing this political the spectrum play itself out in the courts. Now, there's another one. The reason why I'm talking about this, because again, this individual from the office, the special counsel to the Office of Special Counsel, has nothing really to do with labor and employment law. But just this week, just a couple of days ago, I think you will remember that I have talked about the Trump administration firing one of the members of the National Labor Relations Board, Gwen Wilcox. And she commenced litigation against the Trump administration also in the D.C. Circuit Court. And during that argument, the judge in that case, Judge Burl Howell, basically expressed some skepticism of Trump's ability to fire this particular NLRB board member. And so that one would play a role in the labor and employment realm if she were somehow to have her termination overturned. I'm not going to get into all of the nuances of the arguments that were made. We don't have time for that, or I'm sure our audience wouldn't be interested, but it was interesting that the judge did express some skepticism in that. Now, I want to shift gears a little bit. This is kind of related, although it's different. It doesn't deal with the firing, but we also know the Trump administration has taken a very firm position that there are only two genders and that this is the official policy of the United States. And so what that means is that the Equal Employment Opportunity Commission on cases, there's I think 6 of them, that the EEOC had brought during the Biden administration on behalf of transgender employees around the country against various employers. And in one of these cases that's pending in the Northern District of Illinois, this is pending in front of a judge, Andrea R. Wood. She was appointed by President Obama. And what happened is that the EEOC in that case on February 14th filed a motion to dismiss a Title VII complaint it had filed in September 2024, accusing the Chicago pizza chain Reggio's Pizza of unlawfully firing a black trans employee after she complained of harassment. And so, again, based on the Trump administration's announcements and position on that there are only two genders and that this is the official policy of the federal government, the EEOC sought to dismiss the case, and this judge has basically said, wait a minute, not so fast. I'm concerned that if you dismiss the case, that this individual, who the judge refers to as they, interestingly, in the decision, or in the argument, the judge is saying here that before you're allowed to dismiss this case, I need to make sure that it doesn't harm the individual's ability to bring the case on their own. And so, again, we're just sort of seeing all of this play itself out in the courts. The judge noted that this is going to be something that's probably going to be taken up on appeal anyway, but she wants to make sure that the EEOC dismissing the case does not harm the individual's rights to bring the case on their own behalf.
Thanks for being an on-demand viewer of This Week at Work. Don't forget you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.